Hello.
Hello, Anastasia. How are you?
Hi, Jen. So it's time to start. I guess that all participants who wanted have already joined us. So as the floor is yours, you're the first speaker.
I'm happy to proceed. Well, good afternoon, everyone. It's lovely to be here with Vegas Lex to present on this highly topical issue of Russian sanctions, both sanctions against Russia and sanctions that Russia may also be implementing. My name is David Savage, and I'm a partner at the law firm Stewarts, where I specialize in international financial crime. Part of my speciality is sanctions, and I have done that both in private practice and as head of sanctions for a private bank here in the UK. I'm joined by Natalia and Anastasia. I won't try and pronounce their surnames because I will no doubt get it wrong, but I will let both of them introduce themselves when they are presenting their sections. During the course of the next hour or so, we're going to be discussing three distinct topics. Firstly, EU and UK sanctions against Russia, which is obviously a very rapidly moving area at the moment. We'll then look at the US. And finally, we'll look at some sanctions-related amendments in relation to Russian commercial procedure. If anyone has any questions during the course of each of our presentations, by all means, do feel free at the end of each of our discussions to raise your hand or to turn on your mic if you can do so and ask a question. We're more than happy to answer anything that you want to pose to us. And if you don't have a question now, but something comes up after the presentation, by all means, do feel free to send us an email. Our contact details will be made available to you all. Let's go into the topic. It's obviously a very interesting area. There's a lot of movement at the moment, particularly from the EU and the UK side. So I will share my screen and we can kick off. Here we go. And if you can't see the screen, someone please let me know, because otherwise I'll keep on thinking everyone can. So let's talk about the EU and the UK sanctions against Russia, which, as it says on the slide, is a rapidly evolving area. In the next 20 or so minutes, what I'm going to be discussing is the EU sanctions against Russia. What happened when the UK decided to leave the EU, what the current EU sanctions look like, what the current UK sanctions look like, what potential future sanctions might be imposed should the situation with Ukraine continue in the vein that it's currently proceeding, and what can you do as a business, whether based in Russia or in the world with a Russian nexus, in order to comply with these various competing sanctions regimes. So let's look firstly at the EU sanctions. As you will all no doubt be aware, EU sanctions were implemented against Russia following the annexation of Crimea back in 2014. It was almost 8 years ago to the day, I think. So those sanctions are what we call sectoral sanctions, and they are designed to impact on various aspects of the Russian economy, including finance, energy, defense, and dual-use goods, which are goods that can be used for both benign purposes and something more nefarious. The EU sanctions currently have a number of people and entities who have been sanctioned. It says there are 185 people and 48 entities, although that may actually be the UK sanctions because that seems slightly low. This EU sanctions also impact on business that can be undertaken in Crimea and Sevastopol, including an import ban on goods from Crimea, an export ban on certain goods and technologies to Crimea and Sevastopol, and a ban on specified tourism services in those areas. The EU sanctions have to be renewed every 6 months following unanimity amongst the EU 27 member states. And at the moment, those sanctions are renewed and are going to be in place until at least the 31st of July 2022. Notwithstanding a lot of the rhetoric that has been coming from the EU about additional sanctions against Russia, there have been, unlike in the UK, which I'll go on to, no additional sanctions implemented as a result of the current geopolitical tensions between Russia and Ukraine. And the reason for that is, in order for EU sanctions to be implemented, there needs to be unanimity amongst all 27 member states. And that's very hard to achieve. It's hard to achieve because different states have different considerations when it comes to the relationship with Russia. Certain states rely on Russian oil and gas. Certain states are much closer to Russia geographically. Other states don't have those considerations. Some states are kind of more powerful, or more wealthy. Other states less so. And so at the moment, whilst there has been a lot of talk about additional sanctions against Russia, no EU sanctions have yet been agreed or implemented following the deterioration in respect of Ukraine over the last couple of months. The situation is not the same in the UK. So the UK left the EU on the 31st of January 2020. And as part of its exit, we implemented the Russia Sanctions UK Exit Regulations 2019, which were implemented under Section 55(3) of the Sanctions and Anti-Money Laundering Act 2018. That act allows us to implement autonomous sanctions against regimes if we wish to, but also aligns the UK broadly with most of the EU sanctions that were in place prior to our exit from the European Union. The sanctions, the regulations 2019 are intended to ensure that the UK can continue to operate an effective sanctions regime in relation to Russia. And there are a number of different parts to those regulations, which I will go on to in a short minute. What are the types of sanctions regimes? Well, they are broadly aligned, as I say, to the EU sanctions. Part 3 of the regulation deals with financial sanctions, which includes asset freezes against designated persons, which can be both individuals and entities, and restrictions on granting credit to designated persons. There are also restrictions in relation to investments in Crimea, including land and trading securities in an entity with a place of business in Crimea. And obviously, with the financial sanctions, as with all of these, there are licenses and exceptions. In respect of the travel sanctions, this is dealt with by Part 4 of the regulation, and it prevents specified individuals from travelling to the UK or being granted visas to enter the UK. And then turning to trade sanctions finally, which is Part 5, these sanctions prohibit the provision of technical assistance, financial assistance, armed personnel, services, funds, brokering services in relation to certain military activities, in relation to military goods and technology, arms and ammunition, dual-use goods and energy-related goods and services, as well as in relation to tourism in Crimea. So a pretty broad raft of UK sanctions that were implemented upon the UK's exit from the EU. Part 7 deals with licenses. And interestingly, in the UK, unlike in the US, we don't have a general license for the provision of legal services. So if we are acting in the UK for individuals or entities that have been designated, we have to go through a lengthy process of getting a specific license, which is a real problem for us UK lawyers. But yeah, that's my slight bugbear there. So that's where the sanctions were. What do they look like now? So as of the 5 p.m. on the 10th of February, so 7 days ago, the UK introduced additional legislation which expanded on that 2019 regime which I've just gone through. The aim of these amendments are to deter Russia from escalating tensions with Ukraine. What these sanctions are not an implementation of asset freezes. We aren't designating more people. We aren't restricting further activity with Russia. It's basically an enabling piece of legislation which will allow the UK to implement further sanctions should the situation with the Ukraine continue. So who is affected by this new regulation? So firstly, you've got businesses of economic significance to the Russian government. Now I hear you say, what does economic significance mean? Economic significance means. Well, rather unhelpfully, the legislation doesn't define economic significance. Rather, it says that the Secretary of State will consider a range of evidence to assess whether there are reasonable grounds to suspect that a person is carrying on business of economic significance to the government of Russia. So it doesn't really help anyone in terms of figuring out whether they may or may not be sanctioned should the situation with Ukraine continue. It's a little bit more straightforward with regards to businesses with a sector of strategic significance to the Russian government. This is another class of businesses and individuals which could be sanctioned further down the line. And I'll go into those sectors in a couple of slides' time. The final category of people who are affected by these new regulations are those entities or persons who are affiliated with the Russian government, including those owning, controlling, or working as a director or trustee of an affiliated entity. So some pretty wide-ranging categories of people, and unlike the previous sanctions in 2019, which were very much focused on the destabilizing situation in Ukraine, what this new regulation has done is allowed the UK to be a lot more wide-ranging in the reasons that it decides to choose to sanction people. So it gives the UK a lot more scope to sanction. I talked about affiliated entities in this slide. What does that mean? So these are businesses which are owned or controlled directly or indirectly by the Russian government. Businesses in which the Russian government holds a minority interest, again, whether directly or indirectly, and a business which receives funds directly or indirectly from the Russian Direct Investment Fund or the National Wealth Fund, or otherwise receives a financial or material benefit from the Russian government. So again, very widely drafted, and again allows the UK, should things develop in a way that the UK does not like, to implement sanctions against a wide variety of people. I talked earlier about sectors which were of strategic significance to Russia, and this is a list of those sectors. Again, very wide-ranging. Chemicals, construction, defense, electronics, energy extractives, financial services, information communications and digital technologies, and transport. So you can see that the UK has really expanded the scope of who it can sanction and what sectors it can look to sanction as well. Interestingly, the UK has also indicated, unlike the EU, that it may at some point sanction Putin, which would be quite a significant step to take, particularly given that Russia is a permanent member of the United Nations Security Council. If I was a betting man, I would suggest that that isn't going to happen in the short term, and that the UK and the EU and the US will seek to encourage a change in tack by Putin by implementing lesser sanctions. Interestingly, there is no trigger event which is included within the UK 2022 regulation. So at the moment, we don't know in the UK what might trigger additional sanctions against Russian entities and Russian businesses. So I think the UK left that a little bit vague so that they can make that call at a time when they think enough is enough, I guess. Then they'll do that in collaboration with the EU and the US, if at all possible. So that's what the sanctions look like now. What additional sanctions could we have? I spoke about that nuclear sanction against Putin. As I say, I don't think that's going to happen anytime soon, but there are a number of other options that are available to the UK and the EU. And those include restricting access to Russian sovereign debt markets, very similar to some of the sanctions which were implemented in 2014. extending current trade sanctions. So we've already seen the types of areas where individuals and entities might be sanctioned. They may extend that to particular types of activity in those sectors. There may be an extended set of travel restrictions. There may also be targeted sanctions in relation to the Nord Stream 2 pipeline. Now, this is a very controversial set of sanctions for the reasons that I delineated earlier on in terms of geographical and oil and gas and oil and gas reliance on Russia. The Nord Stream 2 pipeline has become a bit of a sanctions issue. A number of countries are against sanctioning anything to do with the Nord Stream 2 pipeline, and a number are pro it, with Germany recently stating that they could revoke their German regulatory approval for that pipeline. And again, another one of these nuclear options, in my opinion, is the removal of Russia from the SWIFT payment system. They did this with Iran to much controversy back in 2012. The difference between Iran and Russia is significant. The Russian economy is much larger. There are a lot of companies around the world, a lot of banks which have an exposure to Russian denominated bonds, to Russian denominated securities, stock, etc. And so again, if I was a betting man, I think this would be a sanction of last resort in relation to the situation vis-a-vis Russia. But it's on the table, it has been discussed, but I know that a number of companies, a number of banks, both in the EU, the UK and in the US, have all been speaking robustly with the regulators as to why removing Russia from the SWIFT payment system would not be a good idea. So that's where the sanctions may go. How do you prepare? Well, that's the $1 million, the million ruble question. There are a number of things that you can do as an entity with a Russian base or a Russian nexus. And the first of those is obviously to undertake a risk assessment of your business to understand what your exposure may be if you're in Russia to the EU sanctions, and if you're in the EU to your Russian business lines, whether that's a supply chain, whether that's having branches or subsidiaries over in Russia. So both sides of the coin here should be undertaking risk assessments to see what might be in the impact if more sanctions are implemented. Everyone should be looking at their sanctions policies and procedures, making sure they're up to date, making sure that there are recusal policies in place should individuals have to recuse themselves, remove themselves from certain transactions. I talked just then about engagement with sanctions authorities. I guess this is more for those of you who are joining the webinar from outside of Russia, but essentially you should be engaging with authorities if you have a significant exposure to Russia to try and get a flavor or a feel for where these sanctions might be going. Important for people all over the world is to review contractual provisions. These include wind down clauses, sanctions clauses, force majeure clauses, indemnities, warranties, notice clauses, to make sure that if the situation does deteriorate and it becomes illegal for a contract to be performed, how do you extricate yourself from that in a way that is not going to be a disadvantage to your business, or is going to minimize the impact on the business. So if you have those kind of contracts, make sure you're looking at those various clauses. Obviously engage with banks and insurers to make sure that you're covered, that your insurance coverage isn't going to be invalid as a result of new sanctions, and the banks know if you have lines with Russian businesses, or if you bank with a Russian bank, that you can continue to undertake the transactions which are required for your business to operate. Obviously, counter sanctions are something we're going to be talking about a little bit further on. Make sure due diligence records are updated, training decks are updated, and new training is rolled out to make sure that people understand what these new sanctions are and how they impact on the business. And finally, consider EU, US or UK licenses in order to continue to undertake your business. I can't stress that enough. It might be determined by you that you do have a problem, but you can get around that by getting a license from the relevant authorities. I'm going to be releasing next week a document about all the various things that people can do to prepare for sanctions wherever they are in the world. So do look out for that on the website. As I said at the beginning, that's my part of the presentation over. Thanks for listening. Does anyone have any questions before I hand over?
Yes, David, you have many questions.
Oh,
Just
no.
click at the button, questions and answers, and also there are a few questions in the chat. 4 questions in total.
Okay, so where did you find in the UK amendments the conditions that it shall be enforced only in a situation where Russia interferes with Ukraine? It's essentially, there isn't a requirement for an incursion into Ukraine within the regulations. Basically, what I'm saying there is that the UK government has not given a concrete answer as to when or when it will not implement new asset freezes. And they've done that because they don't know what's going to happen, and they don't want to be limited in relation to when or how they choose to implement those sanctions. So it's a little bit of a grey area, and as with most sanctions regimes, it's a grey area on purpose. Oleg says also cosmetics and food supplements. I'm assuming that's in relation to trade, and everything is on the table, essentially, both imports into Russia and exports from Russia. I don't have a crystal ball as to what will or will not be sanctioned, or who will or who will not be sanctioned. If I did, I would be a very rich lawyer now, because I would be able to go to people and sort them out before they got sanctioned. Unfortunately, I don't have that crystal ball. But I think it's fair to assume that if things do deteriorate significantly, that you can expect there to be very significant sanctions against the Russian economy. And for both the EU, the UK and the US, I don't think anything is off the table. Let's turn over to the chat area now. So number 1, David, you referred to continue.
David, I'm sorry. So you would need to read the question in the chat, because the participants don't see it, so that everybody could understand the question. Okay,
thank you. So the first question was, where in the UK regulations does it talk about the Russian incursion into Ukraine? And the answer was it doesn't. The second question was, is the pharmaceutical sector, sorry, no, that's the other one. The second question is, do sanctions against Russia also include cosmetics and food supplements? And the answer shortly is everything is on the table at the moment. Then moving over to the chat. Again, the continuing situation in Ukraine, is there any description of that term? As I said earlier on, no, there isn't a description. It's very much the political rhetoric which goes around the sanctions, which is where we kind of can take from our various governments in the EU and in the UK, that they're looking at what's going on a day-by-day basis, as I'm sure all of you are, with a view to determining whether there has been an overstep of the mark. And at the moment, there hasn't been. And you're right that things seem to be stabilizing, but that may change very quickly. And a lot depends on the political and diplomatic dialogue which is ongoing between Russia, Europe, the UK and the USA. So it is unclear. It's designed to be unclear. Is the pharmaceutical sector out of scope of sanctions? It depends, Oleg, on the nature of the sanctions in question. So, for example, if the UK was importing into Russia certain chemicals, they could be considered dual use, which would then maybe render them falling within the previous sanctions. In terms of the current sanctions that have just been implemented, let's have a quick look at the sectors. So chemicals, electronics, energy. I mean, it doesn't say pharmaceutical, but remember that these sanctions that have just been implemented, or this regulation that's just been implemented, is very much limited to asset freezes and designation of individuals and entities. So it could be the case that should there be a deterioration, that the pharmaceutical sector could fall within sanctions, or indeed individuals who work for the sector may in fact be designated as well if they're considered to be close to the Russian government. Can I please comment on the limitation of access to arbitration for the companies under sanctions, inability to pay fees and engage arbitrators? We're talking here about access to justice. I'm not an arbitrator, but from an access to justice point of view, obviously you can get the licenses required to instruct arbitrators, instruct lawyers and to pay fees. You can also get licenses for your daily needs. But obviously, there are some concerns regarding those companies that have been designated, those individuals that have been designated, and how easy it is for them to get access to the ability to have themselves de-designated. It's a bit easier in the USA because they do have a general license. We unfortunately don't have that here in the UK, and I don't think we do in Europe either. Are there any risks for UK EU parent company in case a Russian branch office is using financial services of a major Russian bank under sanctions? I think the answer is yes. I think to date there has been very limited scope or appetite for sanctioning UK entities or EU entities where there is a Russian branch doing its normal kind of day-to-day business. But I think that the UK and the EU may look to expand the nature of the sanctions to capture that kind of activity going forward. Obviously, they can decide if they want to sanction particular branches. That's totally within the purview of the EU government and the UK government. So yeah, there is the potential for that. But at the moment, that isn't the case. But it might well change. And I think that is all of the questions. You've got my email address there. By all means, if anyone has any additional questions or just wants to chat about Russian sanctions, I love talking about sanctions, do feel free to get in contact with me. But without further ado, I'm going to hand over to, who's speaking next? Is it, I think it's Natalia, isn't it?
Yep, that's the case.
There you go, all yours.
Thank you. Thank you so much for the insightful presentation, and thank you very much everybody who has found the time to join us today. Let me share my presentation real quick. Sorry, Mikhail, can you help put the presentation on the screen, please?
Just a second.
Maybe it's that the UK has sanctioned Zoom now and stops you presenting.
Such a hot topic, yes, I agree.
Because of your participation, that may be likely given the craziness going on at this stage.
I'll take the blame.
Okay, so let me start by saying that all of us are now bombarded with reports on the impending invasion of Russia into Ukraine, and concerns have been widely voiced by US officials of the highest level, and these statements normally go hand in hand with promises of sanctions that threaten to isolate Russia to the level of very rare countries such as North Korea almost. So unprecedented sanctions were promised by US Senate Foreign Relations Committee Chairman, and just the other day, Deputy National Security Advisor said that the sanctions that US is ready to impose are the most severe sanctions that Russia would face in its history. So my goal today is to briefly navigate through the key aspects of the looming US sanctions and restrictive measures against Russia, offer enforcement actions in this area very briefly, and a number of potential steps that could be taken by Russian businesses for contingency planning and minimizing the damage that could be done by potential sanctions. So next slide, please. This slide symbolizes the various levels of potential restrictions that might affect Russian businesses. So on top, we see the bills that are being discussed quite widely, and there are a number of them. Basically, one of the newest ones is the Never Yielding Europe's Territory Act, or also dubbed as Niat Act, which was introduced to the Senate by Jim Risch only on the 15th of February, forcing me to update my presentation a little. And most widely spoken of, Defending Ukraine's Sovereignty Act, dubbed as the mother of all sanctions. And there are other bills, there always are, such as the Deterring Authoritarian Hostilities Act and Putin Accountability Act, which I will not go into detail today because we can see that the key bills that are being considered at the stage are the Never Yielding Europe's Territory Act, introduced by the Republicans, and the Defending Ukraine's Sovereignty Act, DUSA, so to speak, introduced by the Democrats. So these are the acts that are similar to a certain extent, but there are substantial differences, which I will talk about in a minute. In addition, in this presentation, I will just briefly mention the revisions to export administration regulations to the extent of cybersecurity, as per the interim final rule of the Bureau of Industry and Security, BIS, a potential ban on sale of Russia or sale to Russia of high-tech products containing US-made components. And so let me briefly go through these initiatives and changes to help clarify the meaning and potential impact for Russian business. Next slide, please. So the DUSA, Defending Ukraine's Sovereignty Act, is based on the understanding that if an affirmative determination is made by the president that Russia has engaged in renewed invasion or escalation of hostilities, the DUSA would trigger various mandatory sanctions on Russian political, military leaders, financial institutions, set of industries, which is not, the list of which is not exhaustive, and Nord Stream. With respect to financial institutions, these require the president to impose sanctions on 3 or more financial institutions out of the list of the major banks, such as Sberbank, VTB, Gazprombank, etc. One of the toughest measures is authorizing sanctions on providers of specialized financial messaging services, including SWIFT, and requiring reporting on the efforts to terminate the relevant services to Russian sanctioned financial institutions. Prohibitions on sovereign debt and additional sanctions, not limited to extraction industries such as oil and gas extraction, coal, etc. It can cover other areas, other industries, should the president determine that the interest of the United States, it would be in the interest of the United States security, national security. Next, so as for the status of this act, as I've mentioned before, discussion of DUSA has not resulted in a bipartisan agreement and passing of the bill. However, there's a new bill being discussed right now. So the status is unclear, and negotiations basically are on pause right now on the DUSA. In the next slide, there are just some key takeaways from the Niat Act. It has implemented, obviously, a lot of discussions achieved during the discussion of the DUSA Act. However, it has also expanded on them and made them severe to a certain extent, such as sanctions relating to Russian banks. So the list is broader, and entities owned or controlled may be affected. Apart from that, secondary sanctions are discussed if foreign financial institutions fail to sever ties with Russian sanctioned banks. Sanctions on extraction industry is basically a repetition of the USA with some exceptions. Mandatory sanctions on individuals, such as the inner circle of Russian president and some wealthy individuals, envisages a tricky thing. It can take effect before Russia invades Ukraine. So this is a preemptive step in this envisaged in this bill. And the Nord Stream project, as per the bill, would basically come to a halt. The sanctions would affect the parties that are controlling or operating this project. And well, until the invasion actually happens, the bill suspends it for as long as the German government fails to go ahead with the certification process. The status, again, is not quite clear at the moment. There will be discussions, obviously, and the process might be not very short. However, both parties, the Congress has expressed the position that if there is a drastic military escalation with Ukraine, the relevant bill may be expedited. The passing of the bill may take place within a shorter time frame. As for the likelihood, can you please come back to the previous slide? Mikhail? Previous slide, please. Yeah, that's one thing. So as for the likelihood, of course, there are speculations as to these bills being similar to the bills from hell, that they will not be passed because they envisage too much administrative burden for the US administration and etc. However, strong positions have been voiced that unless there is de-escalation, the bills may be given way, may be passed. So we do realize that according to some estimations, about 7% of the bills actually end up being passed and becoming laws to the extent of sanctions. However, in this particular respect, we are talking about a heated politically situation and politically heated situation. So we cannot really predict how this goes in terms of passing or discussion, some kind of a hybrid version of the two bills. Next slide, please. Very briefly, I would like to talk about the potential restrictions on the relating more to the tech industry and the cybersecurity. Those are more in the export control area. So the administration regulations will be revised, and there will be some changes in the regulation of cybersecurity, export of such programs, solutions, and technologies to certain countries, including Russia. This does not have the direct, this is not the direct consequence of the escalation of the situation with Ukraine right now, but still worth mentioning. The other part of the slide relating to potential ban on imports from the US to Russia. There may be several angles to that. First, Russia, due to potential invasion into Ukraine, might be transferred to the strictest group of the EAR and be neighbors with such countries as North Korea, meaning that there will be strict bans and on the whole country, basically on importing to Russia in general of high-tech household appliances, software, etc. Secondly, some specific measures may be considered, such as sale high technology products containing US components to specific sectors of Russian economy or to specific companies, similarly to the approach that Trump applied in 2020 with respect to Huawei restrictions. These restrictions are extraterritorial, meaning that they can apply to almost any product with US component around the world. Next slide, please. I will not stop on each and every enforcement actions that were taken during the past period. Obviously, OFAC has been very active in the area of enforcement, and some of the examples are on this slide, obviously. What I would like to touch upon here is just the general conclusions or trends that may be traced. So first of all, we can see that both the the number of the enforcement actions and their diversity are growing, they are increasing, and we can see that there's consistent listing designation of Russian entities and persons in as per newly adopted executive orders, and we see more varied enforcement approach from the authorities. Increased scrutiny is also a principle that is expressed in the Treasury review of US sanctions for 2021. And if we are lucky, we can see that the transparency principle will be further implemented in the approach of OFAC in the coming future, the Treasury in the coming future. Next slide, please. Adding up to what David has mentioned about the possible steps to minimize risks as a part of a contingency planning, there is a difference in approach, of course, between action and reaction to the relevant sanctions. So at the bottom, there are some specific measures that can be taken in the event that the company is listed, is designated, and basically it has to resort to the most challenging measures, such as trying to get delisted from the list via administrative procedure or obtaining a license, which of course does not lift the sanctions as such, but at least allows it to conduct certain transactions. However, given the current undertone of the relevant bills, we can see that these actions may be extremely challenging, even in the peaceful of times they are, and therefore the most appropriate approach, as David already mentioned, is trying to prevent potential impact of these bills, of potential restrictions, such as the easier way that can be taken quite swiftly, that can be started swiftly, is the refreshing of compliance rules and procedures of the businesses. There is practice showing that such procedures not only help lift the risks associated with sanctions, but also can help minimize the penalties imposed if the company is already sanctioned or is in breach, or even help lift the sanctions themselves. And the steps for refreshing compliance rules can, of course, be focused on the evergreen procedures and rigorous screening process, taking into account the current bills and initiatives of the US authorities. Transaction guidelines may be updated to incorporate processes for sanctions screening for the deal from the start to closing. Contractual clauses may also be envisaged in there. And of course, a proper mechanism would need to be checked and be in place, audited, for these measures to be complied with from the top to all other employees at the company. Next, please. So very briefly, the takeaways that might be made based on the points I've mentioned today. With respect to sanction-related bills, there's still ongoing turmoil, ongoing discussions. The process may take quite a lot of time, especially if the US government cannot demonstrate that there is obvious escalation of the situation by Russia with Ukraine. So it is more than likely that both the DUSA Act and the Niat Act will be subject to further discussions between Republicans and Democrats, and perhaps they may come up with a certain hybrid version, and these initiatives definitely need to be worth following up closely. Measures affecting tech sector are obviously not going anywhere, especially given the announced positions of top US officials stating that this sector is key for putting pressure on the Russian president. So these measures are likely to increase in the near future. With respect to enforcement, obviously, there's a growing number of actions, cases, the diversity and complexity. And we understand that the scrutiny is also increasing, taking into account that certain violations of certain directives, like Directive number 4, for example, by Crimson, was detected just this year. So there's increasing efficiency of such scrutiny. And refreshing compliance mechanisms and options for actions in case of different scenarios that play out, subject to the bills, subject to the discussion, is of course key for contingency planning of the business. And all of us here will be happy to lend a hand with that. Thank you very much. So I can see a question that regarding sharing presentations. The presentations, I understand that they will be shared.
Yes, sure. We will circulate them as soon as we finish the webinar. And also a video record of the webinar will be available on the YouTube channel of VEGAS LEX, so it's possible to refresh the information in the future. So then the floor is mine.
I guess so.
Yeah. Hello, everyone. First of all, thanks, David. Thanks, Natalia. Hello, everyone. I'm happy to see you all here in this interesting discussion. I'm afraid that I will talk about 20 minutes, but anyway, we have so many questions, interesting questions, that we cannot comply with the timing. So I'll take 10 seconds to introduce myself. My name is Anastasia Cheredova. I'm heading the Special Projects Group at VEGAS LEX. We handle non-standard complex disputes, usually at the border of few areas of law and sometimes in jurisdictions. And I'm really passionate about cross-border dispute resolution and international projects in general. And I'm privileged to join our colleagues today and cover the Russian part of the topic. So I will help my colleagues to switch the slide as well. Let's start. We often receive requests for sanctions advising, but the requests became different. That's what we mentioned. Until recent times, we and our foreign partners, we advise on the nature of the sanctions. For example, does the sanction regime apply to this company? Will these certain actions violate the sanctions regimes, etc., etc. But now we are more and more asked what to do if the company is in the breach because of the sanctions. So in this part of the webinar, I will talk about options that companies affected by sanctions have, and about first practical cases on application of new provisions in the Russian procedural code. For our foreign participants who attend today, it will be useful to hear about possible risks arising from contacts from relationship with sanctioned persons. So I would like to give a really brief historical background before moving to the main part. About 2 years ago, Russia adopted new articles, new protective instruments to the Commercial Procedural Code. It was a reaction of sanctions, and of course, no doubt that these amendments were caused by the general political situation. An officially declared purpose was to protect Russian citizens, Russian individuals and companies from sanctions regimes. And of course, it all started from one person. It's called the Lugovoy bill. Once upon a time, Andrei Lugovoy, it's a member of the Russian State Duma, was included by the US into the so-called Magnitsky List. Just a reminder, the Magnitsky List is a list of personal sanctions against people who have allegedly violated the human rights. And a year after, he was also subjected to asset freezing by the UK. He was designated by the UK. And later, in 2019, Lugovoy became one of the authors of the amendments, but that we discussed today. And these amendments got the name of the Lugovoy bill. The first draft, interesting, was about the US sanctions only, but the wording was later revised, and the amendments were extended to all restrictive measures introduced by any countries and organizations. It took another year to consider the Lugovoy bill, and finally, starting from June 2020, Russian commercial courts obtained an exclusive jurisdiction to hear sanctions-related cases. And also companies and individuals affected by sanctions may apply for anti-suit injunctions, forbidding the counterparty to start or to continue disputes abroad. We will talk about these new rules in detail a bit later, but the last important thing to mention here, we know that sanctions may be different. For example, sectoral sanctions, they are less severe than personal ones. However, a literal wording of the amendment says that new rules equally apply to all sanctions, personal, sectoral, territorial, etc. It means that even those market players who are under sectoral sanctions may also claim for exclusive jurisdiction over the disputes, as well as to ask for anti-suit injunctions. That seems quite a brave interpretation, brave decision, but that's what a literal wording says. We'll see how it works, as there is no sufficient court practice on application of new provision, and we will talk about that. Mikhail, could you please turn to another slide? So let's briefly look at the first novel. The exclusive jurisdiction extends to few types of cases. The first type involves a sanctioned Russian individual or legal entity, or a foreign entity subjected to anti-Russian sanctions, or who were affected by the application of anti-Russian sanctions. Who might be this foreign company? In theory, this may be a company controlled by designated persons, for example, through a majority shareholding or through holding executive position. The second group of cases are the cases caused by sanctions. So, for example, a dispute arising from the default of obligations, if such a default was caused by the sanctions. And the third category of cases is where a dispute resolution clause providing jurisdiction to a foreign forum, it doesn't matter, to a state court or to a tribunal, to the arbitral tribunal, and this clause becomes unenforceable because of anti-Russian sanctions. So these are the three types of cases when the Russian court is considered to have the exclusive jurisdiction, irrespective of what is said in the contract. A precondition to file an application in Russia is that there must be no similar ongoing proceedings abroad. Otherwise, there will be necessary to apply for anti-suit injunctions if there are any ongoing proceedings abroad. Actually, so many questions arise from this rule. It's only one article, but it gives ground to many questions. For example, as a rule, a claim must be filed with the commercial court at the claimant's region, at the claimant's location. But we remember that we've just discussed that foreign entities may also act like claimants. And in this case, the question is, which Russian commercial court will be competent to consider this claim? There's no answer, no precedence, and I think that the first foreign entity which will ever use this rule will go through seven circles of hell before the court, so we'll correctly interpret this law provision. Second question, may the commercial court consider disputes involving individuals. It's not obvious from the amendments, but seems like yes. And we'll talk about it later. There is an interesting case in the commercial court right now. We will discuss it a bit later. Another good question, which is not on the slide, but I should mention that, for example, may the Russian person sanctioned, let's say by the US only, file a claim in Russia based on the exclusive jurisdiction rule if the contract says that the dispute must be resolved in, for example, LCIA, and the counterparty is from the UK. So you see that I mean, yes, I mean that a situation where the sanctions were introduced by one country, but the dispute must be resolved on the territory of another country, for example, in the UK. Again, no answer. We are very limited in timing, and I will go further to anti-suit injunctions. Mikhail, could you please turn the next slide? Yes, anti-suit injunctions. This instrument is known in UK as well as in Europe, but an interesting thing about Russia that this instrument was specifically introduced for combating sanctions. This may seem weird for foreign listeners, but let's call it our uniqueness. Specialty. Briefly speaking, an application for anti-suit injunctions may be filed if there are pending disputes abroad or there are sufficient grounds to expect that such disputes will arise in the nearest future. Should be mentioned here that if the opposing party breaches anti-suit injunctions, it may be brought to responsibility. However, I personally doubt that the court's award for recovery of penalties will ever be enforceable somewhere outside Russia. I don't see that it will work. And now I suggest to look at the practice. It's very interesting on application of new provisions. Next slide, please. So look at the left column. You will see the cases that happened before the amendments were introduced. For foreign participants, I will explain here that the Commercial Procedural Code has always allowed to ask for temporary provisional measures to secure the claimant's interests for the period of the proceedings. The list of provisional measures is non-exhaustive, but it doesn't directly specify anti-suit injunctions as a separate type of provisional measures. Therefore, in few cases, claimants tried to obtain provisional measures forbidding to continue arbitration, but the attempts were unsuccessful. For example, in the first and the second cases, the first one happened 20 years ago. As far as I remember, the courts of first instances, they granted these measures, but they were cancelled in higher courts. What I wanted to demonstrate in the left column is that the courts were very conservative before the amendments. In the right column, you may see recent cases about the new rules. In the first case, commenced by Uraltransmash against the Polish company, the courts were still conservative. They declined the application of anti-suit injunctions, but later this case became a positive precedent, a positive for Russian companies, but not the foreigners, of course. I will talk about in a separate slide on the next slide. Briefly tell you about other recent cases. A claim filed in the second case was against the Ukrainian company, the Tech Vostokenergo. The claimant was sanctioned by both the US and the Ukraine, and the parties to the contract previously agreed to pass all the disputes to Stockholm arbitration. However, the banks, Russian and foreign banks, they declined the claimant's transfers of arbitration fees. And based on new rules, the Russian Commercial Court confirmed its jurisdiction and considered the case here in Russia. The third case, Sofracht against Prosperity Estate, is interesting because the court of the first instance granted anti-suit injunctions from the first attempt, but rejected the claimant's request for compensation. The court said that first, it's the court's right to grant the compensation, and secondly, the claimant failed to prove the existence of any proceedings abroad. The Cassation Court disagreed and ordered to reconsider the latter conclusion. Of course, we don't know all the facts, but it follows from the ruling of the Cassation Court that the claimant tried to deliver information on foreign proceedings in the first instance. We will trace this case, as we may see an interesting interpretation of the law here about the court's right or obligation to grant a compensation, to award the compensation, and also understand the standards of proof in such category of cases. And the last case also filed by Sofracht against foreign individuals. 2 slides ago, I was asking a question on whether disputes involving individuals fall within the competence of commercial courts. In this case, the Court of Cassation said that yes, he disagreed with lower courts who came to an opposite conclusion first. They said, the lower court said, that the defendants are not entrepreneurs. The dispute has no economic background, and the case is beyond the competence of commercial courts. But as I said, this conclusion, the Court of Cassation disagreed with this conclusion, and now the case is ongoing in the court of the first instance again. One more thing why this case might be interesting is because Sofracht was subjected to UK and US sanctions, while the defendants, the foreign citizens, they seem to be Indian citizens. I'm not 100% sure about that because the details are not provided in the court's ruling. It's not enough information to conclude this for 100%. But we know that the dispute is related to property in India. So if the forum selected by the parties, by Sofracht and foreign individuals, was other than UK and US, for example, any Asian jurisdiction which is close to India, then we expect to read in this case about why the court considers that it has an exclusive jurisdiction over the dispute or not. So that's been a long slide. I know, let's move to the oral transmash. Yes, case, thank you. As I have already highlighted, this case became a positive precedent for a sanctioned person. It's all about the anti-suit injunctions. I will briefly explain the factual background and the findings of the courts through instances. The first 2 instances declined the claimant's application for anti-suit injunctions. They said that the claimant, in fact, actively participated in Stockholm arbitration. The court said that there are no barriers to justice and the company may effectively defend itself. I believe that that was still a demonstration of the conservative approach from the past. However, an interesting thing happened in the first Supreme Court. The court gave a detailed interpretation to new rules. First, the court said that there is no need to prove barriers to justice. Being sanctioned is enough. Second, sanctions affect the companies and individuals by default, at least their reputation. It means that the parties are not equal in the foreign jurisdiction. They are not equal before the court or the arbitration. Third, the court said that there are serious concerns to suggest that fair resolution of these disputes abroad is available, is possible. And the last one, the court highlighted that it doesn't matter whether the sanctioned person participated in the proceedings or not. In the end, the Supreme Court actually upheld the decisions of lower courts and declined anti-suit injunctions, but the reason was was different because by that time the arbitration tribunal in Stockholm has already rendered the final award, so it just made no sense to grant anti-suit injunctions as the dispute was resolved. However, these findings, they became a turning point in the practice of the courts. What to say? Given the number of unresolved issues and so many questions rising from new provisions, I may suppose that in the next 2 or 3 years, the Supreme Court will accept and consider the majority of claims rising from sanctions-related disputes. because you understand that it's necessary to create the unified approach of lower courts, and each case will become a precedent, in fact. And in the end, we ran out of time. I will spend 2 more minutes to summarize the speech. Mikhail, could you please switch to another slide? So the main idea that I wanted to highlight is that these amendments ricochet not they protect Russian business, but they ricochet foreign businesses and make relationships with Russian counterparties quite dangerous and unpredictable. Let's be honest here that foreign companies, they dislike the Russian jurisdiction, especially when it comes to dispute resolution. But these days, they may have to litigate in Russia, irrespective to their own will. There are so many questions remain unanswered, as I said, and I'm really looking forward to new interesting developments in court practice. As you may see on the slide, even though there are only few cases where new rules have been applied, there is already a new draft law, if we'll talk about the future, which extends the exclusive jurisdiction to damage claims caused by sanctions. All I wanted to say here to our lawmakers, please stop, give your Russian lawyers some time to handle the questions rising from the first law. And fortunately, this draft law got a negative feedback from the legal department of the Russian State Duma. And because of that, there's a chance that it will be declined. Well, we'll see. It's necessary to trace the amendments and developments of the court practice of the laws on a daily basis, almost. On that note, I should stop my presentation. Thank you all for listening for an hour. Let me check the questions if there are any. No questions to me. David, he has answered all questions available. Yeah, so David, probably would you like to summarize our discussion?
I would love to summarize, other than your section, which I just think is absolutely insane that they're changing the law again. I feel very sorry for you. I think the take home from this is, at the moment, the situation is very much in flux. There's a lot of political posturing, but no actual new sanctions have been implemented against Russia yet. But that doesn't mean that companies with a nexus to Russia shouldn't be preparing for sanctions to be imposed at some point. We don't know what that point is. Both the US and the EU sanctions do not demarcate a crystallized form of what an incursion or an aggression looks like. So it's a case of keeping a watching brief and making sure that as a business, you are aware of your potential exposure should there be additional sanctions. When it comes to Russian anti-suit injunctions, I guess the take home is, even if you have a contract abroad, you're probably going to be ending up doing your lawsuit in Russia anyway. I'll take that back to some of my colleagues here in the UK. But I just wanted to pass on my thanks firstly to Vegas Lex, to both of you, Natalia, Anastasia, for an amazing webinar and for really, really interesting topics, which were very clearly presented. And secondly, to all of you who've taken some time out of your lunch break or whatever break it is to spend an hour and 10 minutes with us going through some really interesting topics and things that I think are going to continue to change. And it might be worth us doing another one of these in 6 months' time to see where we are.
Thank you very much, David. It was a pleasure to see you first, to hear you, thank you for sharing your experience and your view on the situation. Natalia, also thank you for participation. Colleagues, so we're finishing our webinar. Should you have any questions to David, to Natalia, to myself, please text us via emails, via social networks. We are available for further discussions, and we'll be happy to answer your questions.
Goodbye. Thank you, everyone.
Goodbye.
Thank you very much.
One
a
small
good
question.
day.
Oops.
David is already off the grid, but well, if the question is not to David, then we'll be happy to answer it.
That's the opinion, not the question. Sorry. Thank you so much.
Bye. Я отключаюсь, коллеги.
Спасибо. До свидания.